will introduce the book. The caption. Good evening, everyone. And amongst us, we have Dr. A.Vijayalakshmi from the School of Excellence in Law in Tamilnadu, Dr. Ambedkar Law University of Chennai. She has just recently written a book which was launched and thereafter is being well received in the market. Therefore, we thought that why not have a topic on international criminal law, a jurisprudence perspective, and especially after this notification and the BNS coming into force with effect from 1st of July, the interplay regarding all this would also be seen across, and we are thankful for Dr. Vijayalakshmi for accepting our invite time and again, but we know that we keep on getting the requests that we should bring Dr. Vijayalakshmi, and we are obliged that she accepts our invite. Thank you, ma'am, for accepting our invite. Over to you. And while doing the screen sharing, you just share that book also, and on the WhatsApp group also, you will share the link of the book.
Sure.
Over to you, ma'am.
Thank you so much, sir. And every time when we receive any invitation from sir's side from Chatrak Law Associate or Beyond Law Series, I never say no. And this time, once from the day of publication of my book, sir was asking me to conduct this an interactive session on introduction to international criminal law. So today I got an opportunity to meet you all on this virtual board, on this virtual meet, to discuss about this introduction about international, not an introduction about international criminal law. It's a discussion about international criminal law on the jurisprudential perspective. So this is not the discussion about the international criminal law, but the jurisprudential evaluation and what are the judgments behind this. This is what we are going to discuss. And at the end, I will share the book what I published recently. On May 8th, I published my book on this international criminal law, a jurisprudential perspective. So with this, I'll just share the PDF of this book and I will go accordingly. And before getting into this, what is this international criminal law? How come it differs from international law? Because on the one hand, we have international law, private international law, or maybe the public international law. On the other hand, we are talking about this international criminal law. So whether international criminal law is a separate discipline of international law, or it is one of the supplementary of the international law, if you could see, is that it was a long pending discussion whether we can go for a permanent international criminal justice system. So we have a domestic or regional criminal justice system. And about this international criminal justice system, what about the question on this? Whether we can apply international law on the criminal liability or the criminal responsibility if it is committed in an international scenario, or whether it can be considered as an international crime. Is there anything by name called international crime or crimes? Is there any judicial body to discuss about the crime which has been committed internationally, or some act or omission which should be discussed or to be considered as an universal jurisdiction of this? So for this, we just started about from the definition part or from the evolution part or the introduction part from the international criminal law. So if you discuss about this, it will go way back from the year 1945. Even before that, we could see only these either League of Nations or other thing. But after the formation of United Nations Organization, or after the fall of this World War II, so the victorious countries or the defeated country. So that is the initiating point that we start to think about a separate judicial body or an individual judicial body that talks about the responsibility of an individual irrespective of the nationality for the offense committed. So that is the moment where we started to think about or to talk about this international, not an international criminal law, because at time again there are various instruments, treaties were also there. So in spite of that, then we have this, after that only we got this International Court of Justice, Permanent International Court of Justice. But even before that, if you start to trace about, if you want to start to go back and to search about the sources of international criminal law, to somehow it will go and touch with this Nuremberg Tribunal or Tokyo Tribunal or technically it is called as International Military Tribunal or International Military Tribunal for the Far East, or Control Council Law number 10. So from there onwards, the emerging point or the development or the introduction of criminal law started to discuss about in this. So when you talk about the international criminal law, there is no much difference what we are following in India or what we are following in other countries. The base of the criminal justice system has nowhere been disturbed in international criminal law. Both are same. So whatever we are following in our system, what is called the mens rea or actus reus, the elements, everything are the one and same base for this. And more particularly, the question of principle of legality was an undisturbed or which has undisputed basic foundation of this international criminal law also. So when it comes over there, for example, if you think about this Nuremberg Tribunal, and what is this Nuremberg Tribunal or International Military Tribunal? So the succeeding country, the victorious powers, they formed tribunals to prosecute and punish the war criminals of World War II, that is the German war criminals and Japan war criminals. So two tribunals has been established, and the third one is Control Council Law number 10. So what is this Nuremberg Tribunal? It's a tribunal which is meant for, to prosecute and punish the German war criminals. And Tokyo Tribunal, it is for prosecute and punish the Japan war criminals, and that too, these two tribunals prosecute and punish the high category of or the superior most categories of the war criminals, like commanders. So for example, it may be the ministers or maybe one of the head of the authorities. In such a way, high category of persons has been tried in these two tribunals, and the soldier level criminals has been tried in the Control Council Law number 10. So in this, either it may be the International Military Tribunal, or it may be the International Military Tribunal for the Far East, or this Tokyo Tribunal, or the Nuremberg Tribunal. The base of the jurisdiction of these tribunals were three crimes. One is crime against humanity, war crimes, and crime against peace. So these are the generic crimes that has been are considered to be the jurisdiction of these tribunals, and under this there are myriad of punishable acts has been involved. For example, if it is a crimes against humanity, if it is like imprisonment, murder, deportation, rape. So if it is a war crime, enforced disappearance, again torture, imprisonment, arrest, illegal arrest, all those things come in. So crime against peace. So in these generic offenses, so within that they have followed this punishable act. So this has been challenged in the either in IMT or in the IMTFE also, which means Nuremberg Tribunal and in Tokyo Tribunal also. The perpetrators challenge the jurisdiction of Nuremberg Tribunal and the Tokyo Tribunal. By what? They state that you are going beyond the principle of legality. So what is this principle of legality? What is existing in our constitution, Article 20 subclass 1, ex post facto law, or the maxim of this nullum crimen sine lege, nullum poena sine lege. So what was the crime at the commission of the crime should be considered as prescribed as a crime, and they challenge that the crime what you have been considered as a jurisdiction of this IMT or IMTFE are not a crime either in your country or in our country, which means there is no crime by name called crimes against humanity or war crimes or crimes against peace. So it is not either a crime in your country. It may be US, UK, France, or it may be and it is not a crime in our country like either in Germany or in Japan. So, and this is called the principle of legality. So at that time, a principle of substantive justice was introduced by an criminologist, and he comes with this principle, which is called the principle of substantive justice, which means if any act or omission which shakes the human mankind or human conscience at large, where it speaks about the violations of the human rights or humanitarian right. So we can go over through this principle of legality. So what happened in World War II, the violations committed by the perpetrators of this World War II, they are not responsible. They are not quite enough to consider this, can claim it as a matter of violation of principle of legality. And this was accepted by International Military Tribunal and the International Military Tribunal for the Far East. So for this, it is not a codified or uncodified law. They have their own statute of IMT, statute of IMTFE, and rules of procedure and evidence for IMT, rules of procedure and evidence for IMTFE. So this is a tribunal which created their own laws, and that laws has been meant only for the tribunal, and after the completion of the tribunal, the cases, it will lose its value, So this was the source, an authenticated source where we can get for this international criminal law. So after that, we got this United Nations organization, then we got this International Court of Justice. Again, the question arises whether International Court of Justice can impose or to talk about the international or universal criminal responsibility or individual criminal responsibility. So usually we could see that International Court of Justice, they have only either pass provisional orders or the advisory jurisdiction. They can't impose any penal sanction on any individual because it doesn't have individual criminal jurisdiction or individual responsibility nature of thing where the ICJ can impose. So then this passing, this coming later on, the next source, which is very close to this international criminal law, is or happened in the year 1993 onwards, where a prospective judicial body which has been established by the United Nations organization. So after this World War II, after the establishment of this UN, and with the powers of the United Nations Security Council, under Article Chapter 7 and Article 39 of this UN Charter. So whenever there is a threat to the international human mankind peace and security, the Security Council can take measures to prevent any violations and to maintain the peace and prevent the threat by establishing the proper measures. So with this, in 1993, the first ad hoc tribunals were established. So the first tribunal was established in the year 1993 in the former Yugoslavia, which is called International Criminal Tribunal for the former Yugoslavia, which is meant for, the tribunal is to prosecute and punish the persons responsible for the serious violations of international humanitarian law and the war crimes. So this was in 1993. And afterwards, in 1994, the another ad hoc tribunal was established by the Security Council, that is International Criminal Tribunal for Rwanda. So this is called twin or two ad hoc first ad hoc International Criminal Tribunal, where had the color, shade, or the characterization of exclusiveness of uniqueness of the international criminal law. So the foremost aspect of these two tribunals are, one is universal jurisdiction, the second one is individual criminal responsibility. So for the first time after this 1945, after the establishment of United Nations, and after this new contemporary era, after we got this ICJ. So these two tribunals, other than ICJ, we got this. So in meantime, what are the sources they have to refer in this ICTY or ICTR? So the major source for them are some treaties, some international instruments, where it speaks about the violations of international human rights law or the humanitarian law. So a slight difference between international human rights law and international humanitarian law. So either human rights law or humanitarian law. So human rights law or international human rights law speaks or protect the human rights of every individual citizen of this country, of this world internationally, irrespective of the nature. So what do you mean by this irrespective of the nature is that in case of international humanitarian law, those laws or those treaties or those customs and practice protect the humanitarian law only during the time of war. That is humanitarian law. But in case of human rights law, irrespective of war or irrespective of the conflict, it should protect the rights of every individual citizen in nature, any time of the day. So in this, either the war crime, either the ICTR or the ICTY has its own statute, has its own RPE, rules of procedure and evidence. So this is called statute of ICTY, statute of the ICTR. So here, the development of the sources of this international criminal law during this period. For example, I can give some treaties by name called the foremost and the most important, or the crust of the international criminal law is in the year 1944. It was been introduced by a Polish doctor or an professor who coined the term genocide. So in his most celebrated work, Axis Rule in the Occupied Europe, for the first time, he introduced the term genocide to the international community. And this genocide is a combination of two words, geno and side. So geno is either tribe or a nation, and side is to cut or kill. So genocide is a combination of Latin and Greek term. So it speaks about it's a particular either causing death of a tribe or a group. And for this, in the year 1945, he submitted a proposal to the United Nations General Assembly for a convention on this, convention on crime to punish and prosecute the crime of genocide. So he submitted this convention in the year 1946 with the United Nations General Assembly, and after varied deliberations in the General Assembly, and at last in the year 1948, United Nations General Assembly adopted a convention on this crime of genocide by the United Nations General Assembly. This was one of the major and remarkable and phenomenal development towards the international criminal law, where it exclusively speaks about the characterization, the mens rea, the actus reus, punishable acts, procedure, and everything about a particular international crime of genocide. So this is one of the jurisdiction. The next one is war crimes. So for the war crime, we are having the 4 Geneva Conventions and its 2 additional protocols. So 12th August 1948, Geneva Convention 1, Geneva Convention 2, Geneva Convention 3, and Geneva Convention 4, and its 2 additional protocol 1971. So these are the major sources for the war crime. But with respect to crimes against humanity, there was no any specific or a prescribed instrument on this crime. But it speaks about it may be committed not exclusively on the time of war or armed conflict. It may be committed at any time, but which must be conducted in a very widespread or a systematic manner. So these 3 are the jurisdiction that has been considered to be a crime under this ICTR and ICTY. So with respect to this crimes against humanity or the war crime, with respect to the war crime, there is a slight difference between the crime. The pattern of crime has been mentioned in ICTR and ICTY. So they talk about the Article 3 common in 4 Geneva Convention, or serious violations of Article 3 common to the 4 Geneva Convention. So Geneva Convention 1 speaks about the person who has been on the soldiers who has been affected during this war period. The second Geneva Convention speaks about the shipwreck. Third Geneva Convention speaks about the prisoners of war, and fourth Geneva Convention speaks about the protection of civilians of war. And additional protocol 1 to the Geneva Convention speaks about the international armed conflict, and additional protocol 2 speaks about the non-international armed conflict. So these are the main sources of the war crime. So in 1993, the background of this creation of ICTY, International Criminal Tribunal for former Yugoslavia, because Yugoslavia, why they have mentioned the former Yugoslavia is this? Yugoslavia is having a very very vast history, where it is a combination of varied states, and after these independence, and now, for example, Kosovo, Croatia, Herzegovina, Serbia, Bosnia, Montenegro. So there are a lot of countries in between. So they are separating, they're getting independence and coming back from that. So during the course of this independence, there was a conflict between some countries. So the maximum or the major conflict between the countries are Croatia and Herzegovina, Serbia and Bosnia. So these are all they are the major part. So the background of this ICTY is that the conflict between Croatia and Herzegovina, Serbia and Bosnia. So they are the representative of these two parties filing a representation before the permanent representative of United Nations Security Council, talks about the serious violations and annihilation of mankind in former Yugoslavia, more particularly in these states, in these particular area, which includes murder, sexual offences, more particularly ethnic cleansing. For the first time, the concept of ethnic cleansing has been introduced to the international community in Yugoslavia only, and that too in Balkans. So again, ethnic cleansing, again, it is called CISCING, CISCING, which means to cleanse the society, to cleanse the ethnicity, or to cleanse the particular community. So more particularly, they targeted the Bosnian Muslim by the Croats or by the Serbians. So to and cleanse the society or to protect the society from a particular religion or thing. So they totally either causing a death, murder, or causing serious bodily harm, or by way of their powers, by the opposite party, imprisonment, torture, either forcible transportation, disappearance. So these types of punishable acts are being committed. So when this has been placed before the permanent representative of the United Nations Security Council, so for the first time, UNSC, by invoking their power under Chapter 7 of the United Nations Security Council, under Article 39, they first time established this first ad hoc tribunal for Yugoslavia. So this was the background of creating this Yugoslavia, and when they are creating, established this ICTY, they came up with their own jurisdiction, that means statute, and as well as the rules of procedure and evidence. On the other hand, in 1994, the next year, they established the criminal tribunal for Rwanda. So what happened in Rwanda? So why this ICTR established in Rwanda? What made Security Council to establish a tribunal in Rwanda is that in Rwanda there was a conflict between two ethnic groups. One is Hutu and another one is Tutsi. So in Rwanda, again, it has an, when you talk about the historical background, it went to colonial season, then it comes to the Belgium rule, and when it comes to the actual period of independence, so it is a combination of three ethnicity, Hutu, Tutsi, and Twa. So in this, Tutsi are minority, Hutus are majorities, Twa is only 1%, which means 84% of Hutus, 15% of Tutsis, and 1% of Twa. So here, Hutus are the originate or the son of soils of Rwanda. Tutsis are the people, those who have been came from other African countries, other African states. So after, during this Belgian period, when they are in the colonies of the Belgium, the actual conflict happened. They divided into two groups, Hutus and Tutsis. They created own armies or conflict group, and there was a conflict between. So when this was being taken care by the United Nations, after the establishment of United Nations, they tried to make some peace talks and some make out the proper government. It has to be formed in Rwanda after the independence from the Belgian government. So after that, so in 1994, when the Rwandan president and Burundi, because Burundi is also very close and very neighboring country of Rwanda, so the president is also very much interested in settling down the dispute between Hutus and Tutsis. And the another representatives of Hutus, Rwandese and other thing, when they have been returning from Tanzania after signing a peace accord between these two groups, the flight was crashed in the capital of Rwanda, which means by name called Kigali, and all the person on board was assassinated. This was happened on April 6th, 1994. So that is the moment an immediate conflict erupt in the entire Rwandan city, Rwandan country, where each and every Tutsis has been searched and has been executed. There was a mass execution of Tutsis in Rwanda. In a span of 3 months, they annihilated more than 9 lakhs to 10 lakhs of Tutsis in Rwanda. So again, they sent a representation to the Security Council and citing the establishment of ICTY. And then next tribunal was established in Rwanda, ICTY. So this was 1994. Even before that, from 1950 onwards, there was a talk and there was a deliberation on the establishment of permanent international criminal court, where they should have the characterization of individual criminal responsibility, universal jurisdiction, where they can impose penal sanctions irrespective of the advisory jurisdiction or provisional orders or passing any directions. So they want to impose punishment for this, any violation of this human rights or humanitarian law. So in 1998, they signed a resolution in Rome. It is called Rome Treaty. And in 2000, we got a permanent international criminal court by name called Rome Statute of 2000. So this is what we are following, our international criminal court, which is in the Netherlands. So here in Hague, Netherlands. So here now we got an established procedural law or established substantive law on international criminal law, established or a prescribed procedural law, and in a permanent court to try to prosecute and punish the person responsible for the international crimes according to the jurisdiction of the this Rome Statute. So in Rome Statute, we can state that the sources for Rome Statute are from the jurisprudence evolved in ICTY, ICTR, and the international treaties, and International Law Commission's report, and the judgment passed by the ICJ. So the three offenses or three crimes are common in ICC also, like crime of genocide, war crime, crimes of humanity, crimes against humanity, and the fourth one is crime of aggression. Crime of aggression has been introduced later on, not at the stage of establishment. Crime of aggression was not a crime. Later on, it was included. So these four are considered to be the serious offenses or punishable offenses under the International Criminal Court. This is called Rome Statute 2000, and they had their own rules of procedure and evidence, RPE of ICC. So as on date, more than 98 cases has been indicted in the ICC, and more than 40 cases has been prosecuted by the ICC. But there is there are several allegations against ICC, but the most one is that most of the offenders which has been either charged or indicted or prosecuted or punished are from the African based continent. So there was not even a single perpetrator has been charged from the either European or Middle East or other continent of the world. So ICC is working in it. The second thing is that some country has not signatory of this Rome Statute, including India. We haven't signed the Rome Statute. We are not a member or party of International Criminal Court or ICC. Sri Lanka is also not a party of ICC. US has signed with some reservation, and the reservations, I will tell you when it comes. So, so the interpretation of this international criminal law, now we got an very authenticated, very prescribed nature of judicial body, and as well as the documents we have. So that is, it is not about a temporary and ad hoc tribunal. So the development of crimes, international crimes, crime of genocide, crimes against humanity, and war crime. So I'm not going to discuss about all the judgments, because when you look into the judgments passed by either ICTR or ICTY or ICC, it runs through pages. It sometimes it may go more than 500. So recently, 2022, there is a judgment passed by the ICC, and the judgment runs to the pages of 1077. So in my book or in my research also, I have gone through several judgments in it. But those judgments are a jurisprudential evolution judgments, which gives a new interpretation of the crime. So for example, let's go by crime of genocide. So crime of genocide, which has been introduced by Professor Raphael Lemkin, who was a Jew person who escaped from Germany from the Nazis and came to US, and he started to work here, and he only introduced the term. So according to him, genocide is about three parts. So one is intention, another one is action, and third one is dolor specialist. So genocide is also a crime which we can equate that with either murder or causing serious bodily injury. But this should be differentiated from either murder or causing serious bodily injury, and you need a special intent that is called dolor specialist. So he defined genocide as any act or omission with the intent to destroy in a whole or a part in any group. That group may be race, ethnicity, religious, or national. So how you can commit genocide? Not only simply causing death. Raphael Lemkin described, actually in his article in the Access Rule of Occupied Europe, he discussed about more than 8 or 9 types of 10 types of genocide, like economic genocide, biological genocide, political genocide, educational genocide. But in this convention, which has been adopted by the United Nations General Assembly 1948, they took about 5 types of genocide. One is actual killing or causing death. The number one is causing severe bodily or mental harm. This is the most important thing in genocide. So not only simply causing bodily harms, causing severe bodily or mental harm. And third one is deliberately inflicting living condition of the group. And fourth one is preventing childbirth within the group. And the fifth one is transferring of children from one group to another group. So the first type of genocide is called as physical genocide. First 1 and 2, which means killing and causing bodily harm. The second type of genocide, deliberately inflicting condition and preventing childbirth, is called biological genocide. And the fifth one, transferring children from one group to another group, it is called cultural genocide. So I can give some example through this judgment passed by ICTR and ICTR. For this genocide, for killing, there is a question whether it has to be a mass killing. That is what we understood when you come across the term genocide means mass killing. No, even killing a single person is also amounts to genocide. But that single person should have been killed or caused death of this murdered with a special intention is that you choose a person not because he is X or Y or Z. You have chosen the person because he belongs to a particular race, or he belongs to a particular religion, or he belongs to a particular nationality, or he belongs to a particular ethnicity. So in ICTY, it is ethnicity. And in ICTR, it is ethnicity. And in ICTY, it is religion. So here the pattern of genocide in Rwanda is something different from pattern of genocide in Yugoslavia, former Yugoslavia. So in Rwanda, actual killing is there because the perpetrators, if you could check out the perpetrators of ICTU and ICTR or ICC, you could see it, the ministers, the member of assemblies, the army chief commanders, university officials, traders. So these are the people who commit, because it is called as the type of actionable, this punishable act or actual causing committing genocide, conspiracy to commit genocide, abetment to commit genocide, complicity in committing genocide, and obeying the orders of the higher officials also considered to be a genocide. So in such a case, where an order given by an higher official by choosing this particular ethnic group of people or a particular religious group of people or a particular racial group of people or a particular national group of people and to execute them. So for example, in Rwanda, say they will choose only Tutsis. So here they choose moderate Hutus also, which means who does not favor this extremist Hutus, but they want to be neutral. If they want to protect Tutsis, means they are also being executed. So this execution is mass execution. As I told you, the higher officials, high authorities itself, they supplied the weapons, they supplied the vehicles, they supplied the army groups, they supplied the soldiers. So they supplied the name list, the information where and where they are hiding. They are visiting the place and they have been simply thrashed away everybody. So till today evening, we both are very cordial. Myself and my neighbor, I am a Tutsi and my neighbor is a Hutu. We both are very cordial. And then today night, I'm hearing something over radio or television which is creating a hate crime against Hutu or Tutsis. That day, even midnight, my neighbor came to my house and killing everyone without any mercy. So this is killing. And this the interpretation on causing serious or bodily harm for the first time. In 1948, the convention was established on crime of genocide. In 1998, first judgment on prosecuting and punishing the crime of genocide happened. That is in the judgment by name called Jean Paul Akayesu. The prosecutor was a Jean Paul Akayesu. The first judgment on punishment on crime of genocide. And the most prominent thing in the judgment is that they established the causing serious bodily or mental harm includes rape or sexual violence also. Because during this internal armed conflict, the ultimate target of the Hutu group is of the Tutsi woman or Tutsi girl. So irrespective of the age, either they are being sexually harassed, raped, mutilated, publicly humiliated, naked parade has been committed, gang rapes are being committed, and rape and murders has been committed. So there's a lot of cases just talk about this, and the tribunal is under the chairmanship of Justice Navi Pillai, who was later on the chairperson of the United Nations High Commission for Human Rights, and she was the first woman judge in South Africa who was from the Indian origin. And Justice Navi Pillai or Navanidam Pillai has established that causing serious or bodily harm is also amount to crime of genocide, in this rape as a form of genocide. And on the other hand, in ICTY, so ethnic cleansing as a form of genocide. So what is this ethnic cleansing? So ethnic cleansing, as I told you, that I want to cleanse my ethnicity. I want to cleanse my ethnic group. This was practiced in Balkans, in Kosovo. Here in ICTY, they practiced against the Bosnian Muslims. So what they did is that in one particular region, they totally eliminate all the male members, from the just born male member to the age even 90 or 95 years old male member. Everybody has been taken away and has been mass executed. So ultimately, you are taking away the one gender of the community or the race or the national or religious group, and the rest of the female community are being taken custody by the another group, and they are being again and again continuously being raped or sexually harassed till they become pregnant. And once they become pregnant, they have been detained in a place where there is no scope for escape, and they have been let out only at the advanced stage of pregnancy, and they have to give birth without no other hope. So usually internationally, the childbirth or a child will bear the lineage of the father, not the mother. So that you are without causing death, without causing any bodily harm, or in the name of this causing hurt or something else, you are committing genocide. You are gradually destroying a racial or ethnic or religious or nationality group, and you are emerging a new group or new ethnic group, whatever you want according to your wish. So this is the pattern of genocide that has been committed in. So here they punished ethnic cleansing as a form of genocide, where though it is not being mentioned as a form of genocide in the crime of genocide by the convention or the jurisprudence or the statute of the ICT or ICTY, but the interpretation of the tribunal, the understanding of the tribunal by accepting that causing serious harm. And the third one is deliberately inflicting living condition of the group. So which means where you purposefully denying their basic needs. Suppose if it is a room which is meant to detain only 25 people, but you detained 100 people or some 80 to 50 to 80 people inside the room, very congested, no sanitation, no air, no proper ventilation, no food, proper food, no medication. So you made themselves to die on their own without causing death, without causing any serious bodily or mental harm. So this is deliberately, if the lifespan of the person is 80, he will die at the age of 30 or 20 itself. So this is deliberately inflicting living condition of a group. And the fourth one is preventing childbirth within the group. So as I told you, there are two types. One is removing male members from the group. The second one is the victims of sexual abuses and this sexual violence. So in Rwanda, there are a lot of cases. Even today, if you could go and browse in a Human Rights Watch, the plight of pregnant victim, impregnated victim in armed conflict in Rwanda, you could see a lot of case studies. So that once they have been the victim of the sexual harassment or a rape, they are not ready to get into the normal family life afterwards. The second thing is that the own race or the ethnicity or a group is not willing to accept them within the community. The third one is that they try to commit suicide, or it becomes a prolonged psychological effect on that, so they don't want to get into the family life and give birth to another child. And the child born out of this sexual violence, some mothers go to the extent of killing the child, and some community gave a tag name to the children by name called rape child, and some victims are being sent away from the community. So that this is how where you can decline or you can prevent a childbirth within the group. So it is not a chemical castration, it is not a castration, it is not a, where you can scientifically prevent a childbirth, but psychologically by committing these acts where you can commit a genocide. And the fourth one is forcible transportation of children from one group to another group. So removing a children at the young and tender age and putting them into another culture or another ethnicity, so they will develop into their own ethnicity, which will forget their originated. So in somehow where you can, so as I told you, the another ethnicity is economic ethnicity, genocide, environment genocide, political genocide, educational genocide. So where you are being introduced with a particular type of educational system, where you have been inserted with a particular type of ecological system, where you have been introduced with a particular type of system of political system. So where you yourself tries to either evade away or to forget about your existing. So this is a crime of genocide. And the another interpretation given by this ICTR and ICTR is that the number, question of number. So killing of one person or two person is also amounts to genocide, because you haven't chosen them as Mr. X or Mr. Y. You haven't chosen them because he belongs to or she belongs to this group or that race or that ethnicity or that national group. So this is an example for crimes against genocide. And later on, when it comes to ICC, even ICC also, in the first judgment passed by ICC is that Thomas Lubanga case. But that was not a genocide. It was about involving child soldiers in Sudan. That was the crimes against humanity, and other crimes has been prosecuted. And other cases are there where even ICC also prosecuting persons in a crime of genocide. In 2021, by name judgment passed by the ICC by name called Dominic Ongwen, which was a very unique case where once a child soldier now became a perpetrator. He himself committing this war crime, crimes against humanity and genocide. So in this judgment, ICC, International Criminal Court, has accepted, recognized and acknowledged forcible marriage and forcible pregnancy is also a form of crimes against humanity or war crimes. So for example, during war, internal armed conflict or international armed conflict, the girls and the women are being taken away or being kidnapped or abducted by the opposite party or the component party, and they have been forcibly married into this another group, for example into this Dominic Ongwen and other members, and they have to act as their wife and they have to bear their children. And this forcible marriage or forcible pregnancy was not an established crime in crimes against humanity. So sexual slavery was there, enforced prostitution was there, and pregnancy was there, not forcible marriage. So recently the ICC acknowledged and interpreted that this forcible pregnancy or this rape or deportation is all, which includes forcible marriage also. So in likewise, the jurisprudence are being evolving according to interpretation. And the next one about this crimes against genocide is that psychological, causing serious bodily or mental harm. For the mental harm, there is two cases in ICTY. The plight of victim. So what is plight of victim? So for example, in former Yugoslavia, where the family members who are escaped from the hands of the perpetrators, and when they are being hiding somewhere, they continuously used to hear the gunshots, or continuously used to hear the crying and hue cries and plight of the other victim. Or other hand, there where the victims who lost their loved one, who are in search in the pile of body in the corpus, whether they doesn't know whether their loved one are being alive or dead, they have to go and search among the corpus, a plight of corpus. It's a pile of corpus. So you have to go and search. So this is also considered to be the plight of victim. And the third one, where you made two sit in the next room, and in the another room where you are continuously hearing the sounds of gunshot, where the army is causing death of your own group in the next room. So these are also considered to be there is one of the final judgment, Blogovic versus prosecutor case, where a mother came to the court, this tribunal, because in this case the perpetrator will say that I'm really sorry, unconditionally remorse for the action what I have committed. I want to repent that. I want to involve in rehabilitation process. So kindly reduce my sanction. This was his statement before the court, to the tribunal. Then the mother came and told that, so when we are being transporting from one area to another area, suddenly a roadblock was happened, and the army person, including this perpetrator, come out of the army van, and they grabbed my son, who was 10-year-old son, from my hand forcibly and compulsorily. And my son said that, Mama, keep my bag safely. I will come back and I'll ask you for my bag. That was the last time I saw my son, and that was the last statement that I heard from my son. Even today, I could hear only the statement, whether you want me to forgive this man. And the another victim comes and states before the court that even today I could not take my food. In my nostrils, in my nose, in my mouth, I could feel this smell of smear, which means the pathetic condition of this sexual harassment. So the plight of victim are also considered to be causing serious bodily or mental harm. They are also considered to be genocide by this ICTR and ICTY and ICC. You could ask me, is there any other tribunal established after this ICT or ICTY? Yes, there are several tribunal has been established. Another tribunal is Extraordinary Criminal Court on Cambodia, Special Tribunal for Lebanon, Special Tribunal for Sierra Leone, Bangladesh International Military Tribunal has been established. So other tribunals are also been in Cambodia. It was a Cameroon thing. It was an actual typical tribunal or court for this crime of apartheid, where forcibly or purposefully prevent a basic needs a particular group, preventing the supply of basic particular group. So Pol Pot was there, Cameroon judgment regime was there. So even, but that are all very short-living tribunals. So no much cases has been evolved. And in the case of Sierra Leone and Lebanon, so it was there. It depends upon that. But the most jurisprudential evolution tribunals are this ICT and ICTR. When it comes to the war crime, so when it comes to the war crime, there was always a tug of in ICTY, because they are not ready to accept it as a war. What happened in former Yugoslavia, in a landmark case, Duco Tardik, prosecutors Duco Tardik case, that was even today a landmark judgment on determination of armed conflict, whether it is an international armed conflict or internal armed conflict. So international armed conflict is between two countries, and internal armed conflict between the same country, between two different groups. So here he said that it is an internal armed conflict. So this cannot be considered to be the crimes to be under this war crime. The list of punishable acts are there in war crime. So that in Duco Tardik case, the case has been referred to even ICJ also, because the judgment or the interim order passed by the ICTY was challenged by the Duco Tardik in the ICJ, which means Bosnia Herzegovina versus Croatia and Serbia. So the ICJ come to and they came the advisory jurisdiction is that yes, it is an internal armed conflict which has the characterization of war crime, where they are responsible on it. Likewise, another case has also filed before the ICJ regarding the application of this convention on crime against genocide, whether it is applicable to Croatia and Herzegovina, because this convention was signed before the independence, before the separation of Yugoslavia. The crime was happened after the separation, whether we are binding to this convention, and the court says yes, you are binding to towards the convention. So this is the thing. And now we can apply this genocide into ongoing two conflict. One is in Russia versus Ukraine, and another one is Israel versus Palestine. So even Ukraine has filed an application before the ICC for the crime of genocide committed by Russia against the Ukrainian national group or Ukrainian ethnicity, where it is their intention is to destroy in whole or part the Ukrainian race or Ukrainian ethnicity. And it has been filed, and another case has been filed by Russia before the ICJ for asking the provisional order. So provisional order is that directing the Russian government, Republic of Russia, to prevent further action, further course of action or attack against the Ukraine, but still it is continuing. The next one is Israel and Palestine. I think you all know very well. Last month, the prosecutor of the International Criminal Court requested the ICC to pass or to issue a warrant against the Israel President Netanyahu, and ICC also take the case into action. So again, for the offense of commission of crime of genocide against the Israelis and particularly Gaza Strip Muslim. So still this is a new development towards this crime of genocide in ICC. And the sources has been taken from the judgment passed by the ICJ and ICJ. And with respect to this war crime, there are several acts: imprisonment, deportation, forcible transfer, enforceable disappearance, torture. For torture, they are following convention against torture. So here ICTY, other than genocide, they considered rape as a form of torture. And not as genocide, but rape as a form of torture, and the person has also been prosecuted and punished. So it says that in the judgment, the tribunal says that rape is considered to be an invasion into a body of another person. It amounts to torture. So the torture is also thing. Imprisonment without a proper following the proper guidelines issued by either a UDHR or ECHR or other instruments, or according to the domestic thing. If any person has been imprisoned, that also considered to be the war crimes. And the crimes against humanity, war crimes. So these crimes, this punishable act should be committed either during armed conflict. But crimes against humanity, that is not a mandatory point here. The armed conflict. So it must be a widespread and systematic attack against any group, any civilian group. So here it is not a specificity on race or religion or national or ethnic group. It says wide or systematic attack on any civilian group. So the systematic attack include murder, rape, sexual slavery, imprisonment, torture, inhuman treatment. So all these things. So under this crimes against humanity, two unique judgments are there. One is causing damage or destruction of property. Cultural property amounts to crimes against humanity. Actually, it is a crime against genocide, but they want to consider this as a crimes against humanity. So there is a convention by Hague Convention on Protection of Cultural Property. So not recently, some years back in Sri Lanka, more than 100 years old library was set on fire, where the entire document has been destroyed. So by this, you are destroying a document, an evidence, a witness of a particular ethnic or racial or religious or national group from the future generation, from the existing generation. So if I'm being in the age of 2 or 3, I totally losing my opportunity to know about my history, my origin, my group's history. So this was considered as the thing, plunder of property. So by the army officials. So pleading guilty was also there. guilty was considered to be thief. And more particularly, 2 women perpetrators are being prosecuted for crime against humanity and crime of genocide. So the one is Pauline Naira Masuhuku, and another, this is an ICTR, and in another one is an ICTO. This Pauline Naira Masuhuku was an army chief commander, a woman, army chief commander, and 5 other accused are there, and one of the accused is her own son. So what she did is that her duty is that she always been traveling with 2 or 3 trucks of soldiers with her with a name list in her hand. And the name list consists of names of Tutsi girls, the Tutsi women. And they will directly go to the rescue home or the place where they are staying. So they will list out the girls and they will take the girls out and they will assign the soldiers to go and commit rape on those girls. And before committing rape, she used to circulate contraceptives to these soldiers to prevent any infectious disease. And when she was being prosecuted, the tribunal poses the question, are you repenting something on your part what you have committed being a woman? Because it was a normal and a generalized understanding that women cannot commit a crime, women are so thick. So when the court asked tribunal, are you ready to remorse or repentance, and she said that no, and after having a single percentage or single iota of remorse or repent, I did for my ethnicity. And she has been prosecuted, punished to undergo the imprisonment for a period of more than 70 years for the charges made against her. In ICTY, it was crimes against humanity, where but actually she was not actually involved in it, but she gave orders to the soldiers to go and commit crime against them. But she submitted her remorse and repentance, and she wanted to involve herself in the rehabilitation of the victim. So her sentence has been reduced. And 2 victims are there, 2 accused are there in ICTY, Ratko Mladic and Ratko Karadzik. So this judgment is responsible for ethnic cleansing, where very systematically how they have committed the ethnic cleansing. This comes under both genocide and as well as crimes against humanity of this rape and murder also. So they very clearly interpreted how come murder in one case be fit in genocide, on another case if it fit in crimes against humanity or war crime. If the special intent is missing, it may be either war crime or crimes against humanity. If the special intent, special is there, then it is a war crime. And if we come to the sentencing pattern with respect to crime, this international criminal law is one of the most phenomenal one. I could say this because being a student of criminal law and teaching criminal law every semester, I could say that our criminal justice system is very less bothered about criminological approach. So what is this criminological approach? We are not ready to conduct a study on the perpetrator who is standing before us. We are towards the victim. So unless we study about the characterization, who is he, what was his background, what is the purpose of imposing punishment? But that was very clearly being followed in this international criminal law. So you have a specific portion on the judgment, if you could see, aggravating circumstances and mitigating circumstances. In aggravating circumstances and mitigating circumstances, they could give a clear history about the accused person. The perpetrator, name, when he was born, where he was born, who are his parentage, the siblings, where he studied, what was his higher education, his employment, before his marriage, his sons and daughters. So everything will be discussed to show that his intention, knowledge, and motive in commission of the crime. So in Jean Paul Akaye's case, you could see that he said that being his resignation was burgmaster, which is equivalent to mayor in our country. The court will say that you have totally, when you are having the liability of preventing genocide, but you failed to prevent genocide, but in turn you committed genocide. Being a minister, being a burgmaster. So likewise, a media trial was there for crimes against humanity and genocide. So this is called 3 accused are there. One accused used radio for publishing or propagating hate crime. Another accused used the television for propagating and publishing hate crime. And the third one is used the journal and newspaper for propagating and publishing hate crime. So some witness will come and depose before the court that I continuously used to hear the radio news or the statements by the so and so. His name, one name is Barayag Visa, another one is Nahis, and another one is Ferdinand Nahimana. So the news published by Barayag Visa in the radio, which provoked me to go and commit a crime against Tutsi. When I saw the image that has been published in a newspaper, where it is Kangura, the name of the newspaper is Kangura. In this newspaper, they used to communicate with a hidden double meaning language. For example, there is one statement, there is one, two or three words are there to denote Tutsi, Indian Z. So in Kinyarwanda, which means in Rwandan language, Indian Z means cockroach. So Inkutani means accomplice. Ibitzo means who is protecting the person. So in journal, in newspaper, in Kankara newspaper, they will publish that don't spare Indian Z, kill the Indian Z. And below this statement, they project a image of machets, big knife. Whether anyone can use a knife or a machet to kill a cockroach. Here, cockroach, they are indirectly denoting Tutsi. So as because what happened in the historical background is that Tutsis has moved from the extremist Tutsi moved from Rwanda and they hid in some other place. From there, they start to attack Hutu. They will come during night and they will move immediately during this early morning. So just like the characterization of cockroach, that's what they denoted Tutsis as Indian Z. So whenever you use the term Indian Z, it will directly convey the meaning that you go and attack Tutsi. And the another one is in this television, and they will state that whether a cockroach will give birth to butterfly. Tutsi women are like a snake. Snake will never give you honey; it will give only the poison. So this Tutsi women are being promoted as a snake. So this was being in this media trial. They referred the media trial in Nuremberg Tribunal. Julius Fletcher in Nuremberg Tribunal. How come the Nazis used the television, radio, or other media to propagate the hate crime? So here also this another one is this no such media crime in Yugoslavia, but in Rwanda these three criminals has been considered to be an offender and they are being punished for genocide, war crime and crimes against humanity, and causing harm or for murder, crimes against humanity. There are several cases where a pregnant mother was being when the mother was alive, her abdomen was cut open and they removed the fetus from the mother's abdomen and kept aside the mother. And when the child was continuously crying, they smashed the head of the child, or they cut the breast of the mother and gave it to the child to eat, or inserting foreign bodies inside the private parts of the woman. So these are all the things where they have committed during this internal armed conflict in Yugoslavia and as well as Rwanda. And later on, it comes to this. Even in Al-Bashir case, which is going on in Sudan, again, Congo, Democratic Republic of Congo, or Sudan or Uganda. So again and again, what I'm stating is that in the sentencing pattern, they established the motive, they established the intentional part, and they deliberately allot a particular space for the aggravating mitigating factor, which gives us to understand why they come to such a conclusion. And the second thing is the protection of witness, the identity of the witness. Nowhere, now only we are in the concept of victimology, and now only we are in the concept of giving false or fictitious or other type of names to the victims and the witnesses. But this was being practiced even in the 90s itself in the ICT and ICTR. the sentencing pattern. And the one of the major thing is that as it has been established by the United Nations Security Council, they refuse to prescribe death sentence as a form of punishment. So in agitation towards this, to show their agitation, in Rwanda, they parallelly established another tribunal by the Rwanda government by name called Kaka Court. There they conducted their own trial, and they made committed the public execution. But that is not in a case of ICTR. There is no death sentence. In ICTR also, even ICC also, there is no death sentence. So sentencing pattern comes with this. So aggravating factor will be there, mitigating factor will be there, and there is a clear indication, discussion about the witnesses and protection. There is a separate unit in ICTR, ICTO, and ICC also, where you could see a witness protection, victim protection units are there in international criminal law. So in the BNSS, what we are going to have from July 1st onwards in Bharatiya Nagarik Suraksha Sanhita, a separate portion was there for the victim protection, but this was practiced or this was introduced in international criminal law earlier before itself. And when it comes to this ICC, whether a case can be directly taken into note by them means no, there is a procedure. First, you have to exhaust your remedy, which means you should have filed a complaint in your regional court. You should have get a judgment, and if it is not proper, then only we can file a complaint before the Security Council or before the ICC, the prosecutor. So when I'm being not a member of ICC, how can I file a complaint before ICC? So when not a signatory of the ICC, International Criminal Court or Rome Statute, complaint can be filed before the Security Council, and Interpol will conduct an inquiry, and if there is a prima facie established, then only it will go before the prosecutor office of the ICC. So this is what happened in Sri Lanka, when United Nations High Commission for Human Rights conducted a preliminary inquiry into the Sri Lanka regarding the serious violations of this international humanitarian rights. And they submitted that no, even if it is violated, the Sri Lankan government is conducting an investigation on it. So there is a scope for getting justice in Sri Lanka itself. That's why the case has not been transferred to ICC. But in case of Russia and in case of Palestine, so both of them are the signatory of this ICC, and that's why they are filing a complaint before International Criminal Court seeking either justice. Both the country, both Ukraine and as well as is Palestine, they filed a case both in ICC and as well as ICJ. In ICC, you don't want to quote about any convention, but for ICJ, under the provisional order jurisdiction, both the court cases has been filed in the application of this concerning the Convention on Crime of Genocide 1948. And in both the cases, Russia and in Palestine versus Israel case, Jan 2024, only the provisional order came where ICJ accepted the individual criminal responsibility on par with the state responsibility. That was the uniqueness of international criminal law. So where state is also responsible for committing international crime of genocide, international crime of war crime, international crime of crimes against humanity, international crime of this aggression. So in 2015 itself, when it has been challenged by Croatia and Herzegovina, that time ICJ haven't accepted. But this time in 2024, when Palestine filed a case before ICJ for the state responsibility of Israel for committing this crime of genocide against the citizens of Palestine, ICJ accepted that yes, Israel has committed the commission of this, and they passed a provisional order that Israel should stop further attack on Palestine with the genocidal intent. And as it has not been properly followed, that's why only the prosecutor has asked for issuance of warrant against the Netanyahu and the president of Israel. So that the evolution and the development of international criminal law has three unique things. One is jurisdiction, another one is universal jurisdiction, and third one is individual criminal responsibility, which includes state responsibility also. So where you have the concurrent jurisdiction of ICC and as well as the ICJ. In ICC, where you could file a complaint against the individual irrespective of their status. In ICJ, where they could make a complaint only against the state. So that's why I gave an example of this Russian as well as this Israel-Palestine case. In ICC, as I told you, right from Thomas Lubanga or Al-Bashir, or recently I told you this Dominic Ongwen, who was the one of the army chief earlier, who was a child soldier who turned into a perpetrator. So here it speaks about the individual criminal responsibility. So now we got a permanent criminal court, international criminal court, with its an established pattern of its jurisdiction on crime, rules of procedure and evidence, sentencing pattern, execution, and everything. So ICTY has closed its office as because all the cases, including appeal, have been over. In ICTR, some cases are pending for appeal, and ICC start to evaluate. But again, as I told you, the complaint against ICC, International Criminal Court, is that they are not ready to prosecute or receive complaint against perpetrators from either European countries or Scandinavian countries or Middle East or other Asiatic nation, but only against the African region. They are being so far all the perpetrators has been only from the African countries. So that now we are emerging into the international criminal justice system, where we are in an area. And again, the another thing, expectation from international criminal court jurisdiction is that it was a long pending request to include terrorism and cyber crime and the crime of piracy as a nature of crime in international crime. And we don't know when it will happen, but still it is a pending requisition before the ICC and Rome Statute to include these three crimes, because we are entering into the already we entered into the contemporary era of cyber world and digital world, and now we are facing a lot of cyber crimes, and more particularly this digital crime, more particularly on this deep fake or artificial intelligence, so which may be a very big threat to, which may cause serious violations into human rights and humanitarian, which may cause any conflicts also. So it doesn't mean that it is only affecting an individual. If any statement or any publication or any promotion based on hate crime on any, if it is a nature of systematic or a widespread manner, or if it is against any particular national, religious or ethnic or racial group, it may lead to an international crime. At the time, we have to think whether cyber crime is a crime under the ICC, or artificial intelligence related crime is an crime in ICC. Again, this piracy and terrorism is also a crime in ICC. But time may come to include or to introduce like crime of aggression. Crime of aggression is that combating country and the another country where forcibly protruding into the established another country. So crime of there is a very less yes, I'll come to that answer. So far there is a very less judgments on judgments and very less interpretations on crime of aggression, but judgments on war crime, crimes against humanity, genocide are being coming as a generalized pattern. And with respect to this question, how come they are interpreting terrorism? So terrorism till today they are interpreting as war crime. Either it may be the internal armed conflict or international armed conflict. For example, Russia and Ukraine are the international armed conflict. Israel and Palestine are international armed conflict. What happened in Sri Lanka is internal armed conflict between two groups, like Syria and Palestine, then Afghan. So all these things are as of now, terrorism are being considered as war crime according to the statute of ICC. It may be the International Law Commission or the United Nations Security Council or the General Assembly, through their resolutions, may introduce or include cyber crime or terrorism or piracy as international crime at the earliest. till date we have to depend on UNODC only, United Nations Office of Drug and Crime. So under this only, and for organized crime, we have this Transnational Convention on Organized Crime, and for this terrorism, not a specific convention on that, and for piracy also and cybercrime also. So gradually, but if it comes, we could feel it is a full-fledged, or it is an overall combination of crimes which has been covered internationally. So in any part of the world, if any person commits any crime with the characterization of these crime, and if it is not being properly adjudicated or redressed by the domestic or regional judicial system, the person can file through the government. Yes, I come to that, sir. So to the office of the prosecutor of ICC, and they will conduct a preliminary inquiry, and if there's a prima facie, and it will be taken into consideration. So, and if it again, if the person country is not a signatory, then it can be placed before either United Nations High Commission for Human Rights or the Security Council. Okay, so the question that has been asked by them is why even the warrant has been issued by against the Prime Minister of Israel, Netanyahu, then why he has not arrested, or why didn't they stop genocide? So here, so it speaks about that why the prosecutor has filed a petition for issuing an warrant against Netanyahu, but still ICC haven't issued the warrant. If it is issued, then it will be placed before the Interpol, and Interpol has to execute that a warrant against this Netanyahu. And there is a it is not ICC, another, I forgot his name, where the some regional court has issued a warrant. After 15 years only the warrant has been executed. And but the provisional order says ICJ, not ICC. ICJ passed a provisional order in January 1st to 24th 2024 to stop further attack against Palestine, but still Israel is committing that attack against Palestine and Gaza Strip. That is a serious violation of Convention on Genocide. But pathetically, ICJ has no role in penalizing or punishing any state. But this matter should be forwarded to the ICC, where ICC can take the case through the office of the prosecutor. Then if it has been taken care, then Netanyahu and his team, even in ICJ judgment passed into January 26, 2024, it speaks about three ministers. One is the Prime Minister, another one is Minister for Energy, and another one is Minister for Health. The statements passed by them in public meeting, it has been denoted, it has been accepted by the ICJ as it has been passed in the nature of crimes against humanity and war crime. But this is by the ICJ, not by the ICC. If it comes to ICC, if any complaint has been submitted, office of the prosecutor and the prosecutor office are conducting the preliminary inquiry, by satisfying that the Palestine has filed the suit or filed the case before the domestic jurisdiction, and after exhausting their rights in the domestic jurisdiction, then only they can approach the ICC, because ICC is a complementary jurisdiction. It is not a primary jurisdiction. First, we have to exhaust our remedies in the local jurisdiction. If it is not properly addressed or not sufficiently addressed, then only we can move further before the ICC. So that only it has not been brought before the ICC. It is only the ICJ. The next one is geopolitics and international court or law commission. How predict artificial intelligence for seeing one privacy. So artificial intelligence privacy is about it is something. Artificial intelligence by way of making remarks or publishing some statements or passing some statements on the digital medium. For example, when during this Israel-Palestine conflict, we could see lot of statements in our country. Now, one side favoritism towards Muslims, on the other side favoritism towards non-Muslims, or favoritism towards Israel and favoritism towards Palestine. So it may be sometime through this artificial intelligence or a deep fake, by passing or making some comments by stating that this has been passed by some prominent or a well-known figure or a personality. So on this outcome, that's why I gave you the example of this media trial. So I'm not directly involved in this commission. I'm not one of the perpetrators, but I started, I continuously hearing or continuously observing, continuously reading the statements or videos or images were provoking me to act against the another race or religion or national or a group where it may amounts to thing. So as I told you, either Ferdinand Nagimana or Parag Visa or Nagis not even committed even a single murder on genocide, causing serious or bodily harm. There is no deliberately inflicting serious condition. There is no prevention of childbirth. There is no transportation. But the messages passed by them made others to commit. In such a case, it may be artificial intelligence through by way of deepfake or by way of passing comments. So because cybercrime doesn't have jurisdiction, where it may comes one time at more than a privacy. It speaks about the maintenance of peace and security of peace of international human mankind. ICC has already passed a ruling on this matter. So why isn't implemented yet? So it is not ICC. ICJ has passed this thing. ICC haven't took the matter into his hand so far. Even Ukraine has filed a complaint. On behalf of Ukraine, USA has filed a complaint against Russia in the Office of Prosecution of the ICC. But till date, ICC haven't taken into notice or took cognizance of the complaint filed by the USA against Russia. So the procedural aspect says that you have to show that either Russian court judicial system or Ukrainian judicial system has addressed your grievance, conducted a trial or investigation and provide you the remedy, and the remedy is either insufficient or no remedy provided, then only you can approach the ICC. So you cannot directly approach the ICC. That was a drawback. That's why I give you this best example of Sri Lanka. So each and everyone, if you could in the southern part of India, you could see that everyone wants the matter to go before the ICC. But the ICC state that Sri Lanka is not a party to a Rome Statute, so you cannot directly file a complaint in Sri Lanka. It has to go through UN Security Council. When it is placed before the Security Council, Interpol, and Security Council stated that the report submitted by United Nations High Commission of Human Rights states that complaint filed, Sri Lankan government is conducting investigation on that, and the investigation is going in a proper manner. So no need to take the matter for the International Criminal Court. So it has to be concluded in any way, either way, in the domestic thing. Then only we can approach the ICC. So ICC is a complementary jurisdiction, not a primary jurisdiction, and it is an inherited jurisdiction, which means from the ICT and ICTR. So that this is how we have to take the matters into this thing. As I gave you the example of Thomas Lubanga or this Dominic Ongwen or Al-Bashir. Al-Bashir warrant is still in pending. I think it has to be executed. So sometimes he'll be in Uganda, sometimes he'll be in Congo, sometimes he'll be in Sudan, sometimes he'll be somewhere else. So execution of warrant issued by the ICC should be only through the Office of Prosecutor or for the Interpol. So when it comes to ICC, you have to establish that you exhausted the remedy in the local jurisdiction. So mass killing, then why are they denying this as well? Sorry. Genocide means mass killing, then why are they denying this and saying whatever they are doing is not? No. ICC never said that whatever they are doing is not genocide. So Office of the Prosecution should receive a complaint through the either the permanent representative of Palestine to the Office of the Prosecutor or the human rights agencies of the Palestine by submitting this serious violations or grave violations of humanitarian law by the Israel, either through this physical attack or other bombardments. So ICC never says that they are not committing genocide, but it haven't approached the court of ICC. It is an ICJ. ICJ says it is genocide, but ICJ doesn't have universal jurisdiction on individual criminal responsibility. It is only the provisional order to giving direction that you have to stop. If it is not being stopped, again they will give directions. ICJ is very limited jurisdiction with respect to criminal jurisdiction. It may be the contentious jurisdiction, or it may be the so it is talking about Israel, other countries who are supporting them. Supporting a country is not on that legally, but morally, or the other treaties in between them, understanding between them, the agreements between them. So we cannot expect that they are legalizing or they are accepting. But that's what I told you. But why can't nobody is questioning on this serious and grave violations committed by US in Iran and Iraq? We are not, and a lot of violations. So, but whether Russia is being Ukraine is being protected or favored, or Ukraine is being safeguarded by all the European countries, rest of the, other than the alliance with Russian government, all of the countries are favoring Ukraine. So according to internationalist or international opinion, there are civil politics involved in it, because Russia doesn't want Ukraine to be move away from Russia. They want to be under this control for several reasons. But Ukraine want to be totally free from Russia and to enjoy the sovereignty as Ukraine. When UK tried to bring them into this NATO, then only the action comments. So accepting or favoring depends upon the agreement or understanding between the countries, but it doesn't amount to legalizing or promoting the actions of any country, whatever the country, whoever the person committing any serious violation. Crime is a crime. New era of currency rise, cryptocurrency, though it cheated so many across border, any resolution. That's what. So if cyber crime would have been one of the type of international crime, definitely this will be addressed in a proper manner. Cryptocurrency, bitcoins, dog coins, so a lot of things. So that's what we are expecting, being the student of criminal law and international criminal law. We're expecting that even this can be done as a recommendation on our part also. We can send our recommendations to the office of the prosecutor, or to the United Nations General Assembly, or to the Security Council. So resolution in a recommendation by setting that. So these are all the emerging and the most needed aspect to be taken into consideration, converting it as an other than cybercrime, international cybercrime. So it may come to an end in that. And as asked by sir, and so this, I think this is the book International Criminal Law, a Jurisprudential Perspective, which consists of 8 chapters. I will share the PDF form of it now. So this is whether my screen is visible to all. So whether it is visible to everyone. Okay. So international criminal law, a jurisprudential perspective, and this consists of 8 chapters, right from introduction, which means progressive development of international criminal law. The first chapter, which speaks about the sources, background, development, and the problems involved. And the second chapter talks about the crime of genocide, right from the introduction by Raphael Lumpkin and the convention on this, and international codification, then preparatory works on the convention and 1948 convention, and the other countries where they faced genocide, right from Armenia, South Africa, Burma. And Burma, you could see in Myanmar recently, there is a genocide happening in Rohingya and Muslim. That was also in on queue. There was no tribunal is there, and ICC was not been involved in it. But the thing that Bangladesh, as I told you, Cambodia, ECC, External Criminal Court for Cambodia, Sri Lanka, and the ICTR and ICTY definitions, decision that is killing, killing of individual, sexual violence, rape as genocide, and systematic rape as a crime of genocide, and individual criminal responsibilities, committing conspiracy, direct and public incitement, and the judgments passed by the ICTY. Survivors' plight as a time of genocide, ethnic cleansing as a genocide, destruction of qualitative, and this quantitative and qualitative analysis also. And for the crimes against humanity, there was no any specific convention or international treaty on that, but it speaks about only the systematic and widespread attack on the civilian population. So these are all the things comes within this. Here, the punishable offense are murder, crime of extermination, and then enslavement, deportation, imprisonment, torture, and rape, persecution, other inhuman acts. So these are all the punishable acts against crimes against humanity. And war crime, as I told you, four. Excuse me.